now.
First at 6, a sheriff's deputy acquitted on criminal charges is still facing potential consequences for shooting and killing a man in Washington County.
Investigative reporter Kirsten Swanson tells us why a shooting 5 years ago is now raising questions about when officers can be held liable for their use of force. Kirsten.
Kevin, after Washington County Sheriff's Deputy Brian Crook shot and killed a suicidal man in 2018, he argued he was shielded from a wrongful death lawsuit by qualified immunity. But a federal judge recently allowed that lawsuit to move forward. It's a case that's being closely watched by legal experts, that's worrying law enforcement across the state, and that's giving hope to one family. A warning, the videos from this encounter are difficult to watch. From a young age, Benjamin Evans wanted to follow in his father's footsteps.
I was a paramedic firefighter.
Bill Evans said his son was so committed to serving others, he earned his EMT license before he even graduated from high school. Benjamin moved to Minnesota, where he worked as an EMT and volunteered at the Lake Elmo Fire Department. But instead of responding to a crisis, the 23-year-old ended up in crisis.
He advised we were right in the middle of the intersection.
That day, I think everything was piled up.
Benjamin Evans Williams.
After a 911 call in April 2018,
Coming up behind you, Josh.
Washington County Sheriff's deputies found Benjamin with a gun to his head.
Benjamin, please. Let's put down the gun.
I honestly don't want you to hurt yourself, okay, Benjamin? You're a firefighter, you're a fellow first responder, man. We got to back each other up, okay?
At one point, Benjamin unloaded the magazine from the gun.
Are you able to take whatever's in the chamber out as well?
For me, not you. I'm not gonna hurt you. I'm not here for you.
I understand that.
For nearly 40 minutes, deputies tried to get Benjamin to put the gun down.
Keep talking to him.
Please, Benjamin.
Here's the plan.
Can you please put down the gun?
If we get down to the last seconds,
Okay, I want to help you.
we're going to let sleep on him.
But Deputy Brian Crook didn't follow that plan. Minutes later, without warning, he fired his gun.
That's it. That's that simple.
You're right.
You have said everything you should do.
And as Crook approached, he fired again.
Benjamin! Benjamin, drop the gun. We do not want to do this right now. Shots fired! Shots fired! Get EMS up here now!
Benjamin later died at the hospital.
It was a moment when your heart not only breaks, it explodes, and everything means nothing except for the fact you just lost a child.
As a firefighter, Bill Evans has responded to hundreds of mental health crises.
Anytime that we would go on a call like that, if you were in crisis, then you deserved help. That opportunity was not given.
A jury acquitted Crook on manslaughter charges in 2020 after he testified that because Evans never dropped the gun, the 23-year-old was a threat to the deputies on scene. But this civil lawsuit against him is now moving forward and raising questions about qualified immunity. That's the long-standing legal protection that often shields officers from civil liability. But earlier this year, Judge Michael Davis ruled Deputy Crook may not be protected by qualified immunity. In this 70-page opinion, he questioned whether that defense expands so far that it swallows every situation in which an officer uses deadly force against an armed individual experiencing a mental health crisis.
Precisely.
We asked 3 legal experts to review the judge's ruling.
This could actually set the stage for stronger cases.
Here, the judge simply said, if you believe one set of facts, there will not be qualified immunity.
It's been a hurdle that oftentimes we cannot scale.
Kenneth Udoybach and Gregory Sisk say it could have a significant impact on police officers across Minnesota.
When the victim is not posing a threat to anyone, you must not kill. And if you do, it will be consequential.
In future cases, law enforcement will be under even further clear notice that you may not use deadly force against a suicidal individual, even though they are in possession of and threatening to use a firearm against themselves.
But Richard Hodson, the attorney for the Minnesota Sheriff's Association, says the case will have more of a chilling effect rather than a legal one.
If this does go to trial and Deputy Crook is found liable in this situation, like what impact does that have on law enforcement as a whole?
Law enforcement across this country, and I know this because I teach nationally, is having huge difficulties attracting qualified, competent candidates into the profession. They do not want the civil and criminal liability exposure that's associated with being a peace officer anymore.
I grew up with my parents telling me, if you're ever in trouble, go find a policeman, go find a fireman. You see either one of those, you go to them and they will help you. And I'm not really sure I totally believe that anymore.
Deputy Crook declined an on-camera interview, but in a statement to 5 Investigates, Crook's attorney writes that his actions, quote, did not violate clearly established law and that he is entitled to qualified immunity. Crook is appealing the judge's decision. It could be months before we learn if that lawsuit will proceed. Lindsay.
Kirsten, thank you so much. If you or someone you love is struggling, help is out there. You can call the nationwide Suicide and Crisis Lifeline. Call or text the number 988.